First of all, friends, a very warm welcome to all of you to this IPNet webinar in a series of webinars which we have been doing. So I think this is also on a Saturday, 4 p.m. every Saturday. This webinar is organized. So a very warm welcome to all of you. We have got very two important topics to discuss today. The first one is definitely relating to Bhushan Steel and Power Limited judgment, which is a much awaited judgment. We were all waiting for it. And in the second part of it, we will be going to handle or we're going to deal with the how to handle real estate CIRPs. I think that is also one of the important topics, and many of our friends are handling CIRPs of real estate, but they are very typical. So a lot of issues and a lot of problems are coming. So this typical webinar is talking about both the issues. One, we are dealing with the BSPL judgment, and secondly, definitely we'll be doing handling the talking about the other aspect which is there. So this is very important, friends, and not only this, uh, the the judgment of BSPL is extremely crucial because everyone was looking at it at the Supreme Court that we would like to have some kind of a conclusive thing on this BSPL. And we are very fortunate that one judgment has come in now, which came on 26th of September and not very long ago. In fact, on the same day, some of you might have attended my one of the Institutes of Chartered Accountant webinar, where I dealt with it because I looked at it and of course I laid out. But we are going to do it in a detailed manner. So that is what is more important. But before we do that, I think we need to run the IPNet video. But before that is also done, let me also make a small announcement, and that is we are having an IBC conclave on 1st November 2025 in New Delhi. And I think I will request all my friends who are here, and I'll just share my screen in a little while. So I'll share with you what are the details of that. So, okay, are you able to see that IBC?
Yes, sir.
Yeah,
Yes, sir. Yes.
okay. So this is IBC Conclave 2025. The theme of IBC Conclave is Empowering IPs, Strengthening the Code. And this is being organized in association with the Insolvency Professional Agency of uh, Institute, Institute of Cost Accountants of India. And it is a full day conference which will start at 9:30 a.m. and particularly expected to go till 5:30. And this is going to be a very interesting conclave where we are, and it is at India Habitat Center. I think most of you who are in Delhi probably are aware about this. And not only the experts which we have invited, you will be exposed to a lot of experts from judiciary, from regulators, from a lot of speakers will be there. And besides that, it is a great opportunity. In fact, we started with that it should be an IPNet annual meet, but we expanded it to IBC Conclave. So it's like IPNet members meeting each other and having networking opportunities. So a lot of law firms will also be there, and IPs will also be there. And not only that, we are getting 4 CPE hours for attending this conclave. So this is a great opportunity, friends. This is the link which I'll be sharing on the chat box. So please join this. Please register for it. We have early bird registration, which is going to end very soon. So it is very important that all the insolvency professionals, all my friends who are able to attend it, you must make a program, even if you are outside, because we're expecting a lot of people from outside and a lot of participants from Bangalore, Calcutta, Bombay. They have also registered. So we are expecting a good number of people. So I think I'll request most of you, those who have not even registered so far, there is an early bird pricing also. And please do that. Limited seats are there. So it is very important that you should be attending this. So I'll share that link in the chat box. And then, of course, I will request everyone to please join on this. Now, I think,
Physical presence or
yeah, it is a physical webinar, sir. Physical presence, because we thought, see, IBBI is also moving towards the physical programs now. And in
Okay.
fact, IPAs have been told that their 70 to 80% programs should be physical. In any case, we wanted that we have completed 1 year. We wanted all members pan India to come to Delhi to a particular place. This time it is in Delhi. Next time it could be in Bangalore. It could be in Chennai. It could be in Mumbai. So every year we are going to change the location also. So that is what we are expecting that. Okay. So friends, I'll request each one of you to please, I'm just sharing that link in the chat box. So just click this and register it. You will really, really like it. There are a lot of speakers who are, you see, will be there, uh, uh, you see, and you will get an entire networking advantage of that particular thing. So the link has already been shared. And since Mr. Sandeep Chitkara has not been able to, he's the person who was coordinating this webinar today, but anyhow, probably there is some network issue in his this thing. So the first session is going to be taken, probably I'm also there, and of course, Akhil is also there. So I will let Akhil take over now from here. And I think most of us know Akhil also. Akhil, I'll request you to introduce yourself because today Sandeep Chitkara, who was supposed to introduce, he's not there. So I'll request you to just briefly introduce yourself so that
Sir,
everyone knows. And then we'll.
apologies, sir. At this side, Vineet Bhatia. Should I, sir, give an introduction of both of
Yeah,
you,
yeah,
sir?
okay, okay, okay. Go ahead. Go ahead, Vinny ji. Go ahead.
Okay. Dr. Ashish Makija is a distinguished expert specializing in insolvency, corporate law, and forensic audit. He has served as a standing counsel for the official liquidator at the Ministry of Corporate Affairs, representing clients in the Supreme Court, High Court, NCLAT, and other tribunals. Academically, he holds a Doctor of Judicial Science from Emory Law School, USA. He is a chartered accountant, a cost and management accountant, and a listed insolvency professional with 2 LLM degrees. He has consistently ranked at the top of his academic pursuits, earning prestigious honors such as CBSE Gold Medal and Magna Cum Laude in his LLM from the USA. Dr. Makija has authored 14 books and has been involved in various government and professional committees. He also served as an independent director in prominent companies and is a passionate golfer. I'll give a brief introduction of our second speaker, Mr. Akhil Ahuja. Mr. Akhil Ahuja is the founder of Mavent Restructuring Services LLP. He is a fellow chartered accountant, advocate, CPA from USA, registered valuer, and insolvency professional. With over 15 years of experience across PwC, EY, and Deloitte, he specializes in restructuring, valuations, and revival of stressed assets. He is also a trainer with insolvency professional agencies under IBPI and a regular speaker on insolvency and valuation. Thank you, sir. Over to you, Ashish sir.
Thank you. Thank you, Vaniji. Thank you, Ashish sir. And thanks for the team IPNet for organizing this event. I hope my voice is loud and clear. Just confirm once. Is my voice is
Yes,
loud and clear? Thank
Yes,
you.
yes, yes,
yes,
very
sir.
much clear.
Dr.
Thank you. So I request
Yes, sir.
every participant, please make this
Yeah,
deliberation
it
an
is very clear, sir.
interactive one. Please make this deliberation an interactive one. It helps us for a collective learning. The idea of me having this is not that I have a much more detailed analysis of the judgment. The idea is only just to present what is there in the judgment, what could be the thought process of the various judicial level and the Supreme Court in arriving at a particular conclusion, and what could be the practical implication, not in terms of the Bhushan Steel and Power Limited CIRP, but its impact on the other CIRP and in the entire IBC ecosystem. Considering we all are working in a different domain and in different projects, so keep this as an interactive one. And I keep on requesting Mr. Makhija ji also in between to share his comments in terms of on very specific and the pertinent issue that we're going to identify. The way I have this, the PowerPoint is just as a kind of the kind of a checklist form so that the everything could be summarized in detail. The way I'm going to discuss, there were around 9 to 10 issues that has been dealt by the Supreme Court in the latest judgment of September 26th. I just tried to identify out of this each of such issues what is the fact of that matter, what is the view in terms of the NCLT, what is the view of the stakeholders, how the particular thing has been considered into the resolution plan, then was the view of the NCLAT, and also then what is the Supreme Court views in its judgment of the May 2025 and what has been ultimately concluded. So that's the way I'm going to take this up. So moving forward, these are the basically timelines. The idea of having this timeline, the process was started in 2017 and it got concluded in 2025. So there is a time period of 8 years. Within the 8 years, there are parallel proceedings relating to the ED attachment were in place. Due to the ED attachment, the planned implementation got delayed. How the Supreme Court bench has looked into all such delays, that we're going to discuss. And these dates we definitely keep on referring back in another 60 minutes or the 75 minutes. That's why I just plotted for the ease of reference. And the entire discussion for the initial one today has been bifurcated into those 19 topics, which has been deliberated in the Supreme Court judgment and just has been captured here for again for ease of reference and ease of understanding. Now, starting from the first one, if anybody has read it, read the judgment, one of the critical issues with the Supreme Court judgments has touched the concept of the erstwhile COC. We always keep on hearing as a professional, yes, earlier we are an IRP. If we got replaced, then we title and designate ourselves as an erstwhile IRP. Or if our plan got approved or after the NCLT approval, we again designate ourselves as an erstwhile resolution professional. But as such, this terminology is not there in the law. The COC is the statutory body constituted under the IBC. Whether after the approval of the resolution plan, can COC work and take any decision? That is the broader question that has been answered through this judgment also. So, can someone please help me understand what's their view, whether there could be any concept of the erstwhile COC or not? Anyone would like to help me and make this session more interactive? No one? Let me move ahead then. So,
Yes, sir.
yeah, please, Mr. Kabra.
Yes, sir. So I feel, of course, there's as per the judgment that you mentioned, I feel there should not be concept of erstwhile COC because if you are continuing their involvement, you cannot term them as erstwhile. You either continue the involvement and call them current, or if their involvement is itself superseded by any other authority, then it would be a better term to call it as erstwhile COC, just like as an erstwhile RP or RP. That's my view.
Right, sir. See, while we're talking about the word erstwhile, this is not just about nomenclature of this erstwhile COC. It's more about what is the power of the COC. Whether creditors collectively can take some decision after the approval of the resolution plan, after the COC is not there, after the approval of the resolution plan by the NCLT, can creditor takes any decision? We keep on hearing about the wisdom of the COC. Whether the wisdom of the COC is only till the date of the approval of the resolution plan, or the wisdom of the COC can be continuing up till the implementation or up till the full hand holding or up till the ultimate conclusion of the resolution plan. So this is not just the just the impact of the word. It is going to be a detailed impact in the practice. And coming to the NCLT order of the 5th September 2019, wherein the resolution plan was got approved, the plan mentioned recognize that the role of the COC is there even after the approval also. While it is going to be there for the approval, the same has been upheld by the NCLAT also. The only point that is going to be deliberated if there is going to be a delayed in the implementation of the resolution plan, whether that delay can be approved by the monitoring committee by the NCLT or by the COC. So while this judgment we are talking about, the bench or the September 26 order is trying to convey a message that the COC has a limited right to secure themselves, to make ensure what has been agreed in the implementation, they can able to take a decision after the approval of the COC, after the approval of the plan at the NCLT also. Although the judgment of the 2nd May 2025 has a different view, where they are saying that no erstwhile COC concept can be there once the plan is approved. Only it is between the monitoring agency and the SRA, or to the limited extent of the resolution professional who is the part of the monitoring committee, can take such decisions. So Supreme Court latest judgment has overruled the 2nd May judgment and categorically mentioned, although the erstwhile COC is not a statutory concept, but for a monitoring and implementation perspective, they should be keep on consulting on a regular basis till the time the plan is fully implemented. There were a couple of the topic that we're going to discuss in the subsequent slide that has been deliberated among the erstwhile COC. Whether the plan can be deferred, additional 3 month time, 6 month times can be given, whether the cash flows that has been generated during the CRP process, during the detailed implementation, whether COC has a right to discuss upon that. That is where the concept of the erstwhile COC is upheld by the Honorable Supreme Court. So does this make sense? Any question on this, please? And any issues that you think can be arise due to such interpretation of the Supreme Court?
So, Akhil,
What I suggest is right now, maybe we can go on continuing because if we, invite comments and at this stage, because it will delay the whole.
Got it, sir.
So I think
Got it.
if quick comments are there, I think Vikramji is there. So if quick comments we can take, but I think let's move forward.
only one quick point, Akhil.
Yes, Vikramji.
My point is that if the COC exists, then how can you use the term erstwhile?
Sir, the way the order is being written, they are trying to say that COC is not going to be there because COC requires so many decision making. In this matter, the bench trying to convey that COC is there with a title erstwhile for a limited purposes. And that limited purpose is for implementation of the resolution plan.
Then how
Whether
do you
this is going
distinguish between
to,
a
whether
monitoring
this is
committee
going
and
to be clear, because during implementation, the answer is no. Whether it requires ratification from the COC, the answer is no. So only what has already.
You complete the presentation, then we can take up the questions.
Sure, sir. And sir, Makhijaji, I would also like your comments on this erstwhile COC in a quick summary or in a quick two-pointer, specifically considering the few of the question that I have plotted on the slide, sir.
See, Akhil, as far as this judgment is concerned, see, the point is that at the end of the day, the question was before the Supreme Court was whether the COC continues to exist or not. That's a very important question, isn't it? So the point was that whether COC can continue to exist after the approval of the plan, and supposing they have taken decision, because we have seen that in the at the end of the day, most of the time, the when the plans are being implemented, then there are certain aspects which need to be considered by the COC, like whether the extension of time can be given to them or not. So these are the questions which are there. So therefore, Supreme Court categorically mentioned that till the time of the implementation of the plan, COCs can continue to exist. So they do not become, they survive also, whether the COC survives after the NCLT approval. Now, there is another aspect which they have mentioned. That is that, look, if you do not permit the COC to continue or to exist, then supposing the appeal has been filed against the approval of the resolution plan. Now, who is made as a respondent? Generally, the COC is made as a respondent. So if COC is made as a respondent, and if you say COC has become defunct, they cannot exist, then how can they fight the appeal also? So court has actually gone into those kind of details. He said, if we treat COC as functus officio after the approval, it would create anomalies. Now, because plans often face appeals or the implementation hurdles. Now, without a functioning of the COC, they said creditors would be left in limbo and will be unable to act. So therefore, they say COC backed monitoring committee to supervise implementation. They refer to regulation 18 and regulation 38 also. So I think typically what they are saying is that after implement, even after the approval of the plan, COC has a vital stake because it has to oversee the implementation of the plan also. And I think IBC bill, which is also you see pending, it also now talks about the existence of the COC in implementation and also even during liquidation also. So I think this is in the same lines that the whole thing is there. So promoters functus officio claim was rejected by the Supreme Court.
Right.
That is what I wanted.
Thank you, sir. So the next issue is relating to the EBITDA treatment. So what's the background? The CRP started in July 2017 until the plan got approved and later on implemented. There was a significant profits that has been earned in the form of the EBITDA that has been nomenclature in the plan or in the COC discussion. During such period, an amount of 1813 crores has been earned during the period of the CRP period till the date of the approval of the NCLT. Now the question arises, who is going to own, who is going to be ultimate beneficiary of this amount that has been earned during such period? While the COC has approved the resolution plan, they must have received a fractional amount or a 10% or some other amount that could have mentioned in the RFRP as a performance bank guarantee or an EMD. Plan took a longer period for implemented. During the period, the cash flows arises. In this matter, the RFRP is silent, the plan is silent, and the primary reason for such increased profitability during such period is the cyclic nature of the business. The steel prices has been increased significantly from 2019 at an amount of 35,000 metric ton to 55,000 metric ton. This issue was deliberated in detail. The COC keep on asking since the beginning that this belongs to the lenders because it is the lenders' money that has been keep on continuing invested in the business till the time plan is fully implemented. The Honorable Supreme Court judgment on 26 September has mentioned that this EBITDA should be belong to the corporate debtor only, should be belong to the SRA only, and should not be distributed to the creditor, considering the RFRP is the silent and considering there was no discussion in the resolution plan also. The lenders will be entitled only to the 19,000 plus amount that has been agreed to be paid by the SRA to the lender. So effectively, the COC right to receive the EBITDA, the door to receive that EBITDA has been shut by the Supreme Court judgment. This is very interesting concept because there could be so many CRP matters where the cash flows keep on accruing during such period. Even the CRP cost is generally utilized first from the cash flows that has been generating during such period, and there could be so many industries and asset where these cash flows are positive. So message is very clear. While the resolution professional prepare the RFRP documents, evaluate the resolution plan, they should kept in mind the cash flows that is going to be generating during the interim period, during the transition period. And there should be a specific discussion or a deliberation before a specific resolution plan is approved. And the Makhija ji, again, any specific comment on this from your side? Let's say if during this period the EBITDA could have been negative, then whether this could also be borne by the SRA or whether that could be borne by the creditors.
Okay, see, the point is like this. Let's try to understand. Here, EBITDA typically means the profits generated during CIRP because the plant was running and therefore they made profits. The point is, and this thing is absolutely clear. I think there should not be any doubt in anyone's mind. Number one, who has the authority to
Sir, we
decide?
can't hear you, sir.
आ रहा है विक्रम जी, आ रहा है सर का आवाज?
I don't know, but I think if we can increase the volume, it's very, very low voice.
Sir, please.
Yeah, we are able to hear.
Yeah, very clear, sir.
Very clear.
Yeah, voice is coming a bit lower, but we can hear it.
No. Both the voices are
Your
very
voice
clear
is very
and loud.
clear.
Very
Loud
clear,
and
very
Very clear and
clear.
loud, sir.
Okay,
Okay, we'll see. Sir, please you continue.
okay.
I
You just
request them to
ensure
log
to be
out and
more
log in.
closer. Please, sir.
So, see, the point what I'm trying to convey is this, that as far as the position of the profits which are generated during the CIRP is concerned, the Supreme Court has decided a basic principle, and I think that basic principle everyone has to understand. The Supreme Court says that the resolution plan clearly says that JSW was taking over Bhushan Steel as a going concern, which by nature would include both profits and losses of the CIRP period. Now here, in this particular aspect, although COs, because this was an appeal which was filed by the promoters, and there was also JSW, and of course promoters were arguing. And typically COC was always arguing against the promoters also, because promoters wanted the plan to fail, but COC was supporting it. But on this particular point, on the distribution of the profits generated during CIRP, both promoters and COC were aligned. Well, this is very surprising, isn't it? Because COC said, oh, this money belongs to us, to the creditors. The promoters also supported that. The bank, because they said if the bankers will receive more money, naturally their personal guarantee dues will be, lessened, or will become lesser. So idea was both were, on the same page. But the Supreme Court simply said that, look, number one, your RFRP document is silent. While approving the plan is also silent. COC did not never, raised any objection. They approved the plan. Now, if the plan was silent, if the RFRP was silent today, the COC cannot inconsistently, because they said COC had consistently supported this position earlier. They are trying to now reverse the position and claim the profits as an unjust volte face. This is the word which has been used there. So typically, the Supreme Court says that, look, if you are not decided anything, in fact, friends, now you will recall that this is an old case, but now the regulations have been amended. It is mandatory now to mention in the plan itself that who is going to get the benefit of this particular profit which has been earned during this CIRP period. But having said that, Supreme Court clearly mentioned that COCs and promoters cannot reopen this issue now. Both their arguments were rejected, and they say since they are taking as a going concern, it should remain with the company only. See, let's also understand one more thing. We always, say, oh, whether it should go to SRA. Friends, let's understand. It is not going to SRA. It is actually being retained by the corporate debtor. It belongs to the corporate debtor. Now, SRA, they are in the management of the corporate debtor. That's fine. So whosoever takes over the management, well, the money will remain in the company only. It is not going to the pocket of the SRA. So let's try to understand that, because they are taking over the company as a going concern. So I think this was a very interesting point which has been decided by the Supreme Court. Yes, Akhil, go ahead.
Right. So moving to the next topic is relating to the locus of the promoter. This topic was being deliberated within the Bhushan Steel since very inception. And when the CRP application was filed by the PNB under Section 7, this application was not been objected in detail, because this seems to be one of the type of the restructuring that promoter can also do under the CIRP. Later on, the Section 29A has been introduced, which affected their right to become a resolution applicant for the company. They have challenged the application of Section 29A to them stating that this cannot be applied retrospectively. And when they mean to say retrospectively, that the CIRP of Bhushan Power and Steel Limited has already been started in July 2017, and the ordinance relating to the Section 29A came into in November 2017. So it could be applied only to the CIRP that have been commenced after that date. The NCLT has rejected their view. The NCLT have rejected their review that they going to be disbarred under Section 29A. Now the point arises whether they still could have the locus to file such appeals when they don't have a locus to revive this company. They are the shareholder, yes. They are the guarantors, yes. The Supreme Court in the earlier judgment mentioned that they have no locus to file any such application. And in 26 September judgment, they have clearly mentioned that although they are ineligible under Section 29A, but they are the agreed person in their personal capacities. The any liabilities which is not going to be fulfilled by the revival of this company, the promoters are going to be personal liable. And I also believe in practice that could be one of the reason that they keep on insisting or keep on arguing this matter and pushing for the liquidation. Why? This is only my personal thought and personal comment. Assuming that the final verdict could be the liquidation, I assume the realization for the creditor would be much more than the 19,000 crores, because the business cycle has been changed. The underlying valuation of the asset might not have been changed significantly. That could one of the reasons they keep on focusing to get this liquidated instead of it going into their competitors, which could help or revive or could limit their liability from the personal guarantor's perspective also. Does that make sense? So any question on this, please? So the next issue is relating to the infusion of the equity or the compulsorily convertible debenture. So going to the background of this topic, the resolution plan was mentioned for an amount of 26,550 crores. A part amount of 19,000 plus crores to be distributed to the lenders and the creditors, and an amount of 7,000 crores plus needs to be contributed as a equity for a working capital purposes of the corporate debtor. The promoter's argument is that the SRA has never contributed this equity amount in its entirety. The reason being, this amount first might not has been contributed to the 100% that has been mentioned, an amount of 7,000 crores. And also this has, if any such amount has been contributed, it has been contributed in the form of a CCDs. CCDs are also kind of the hybrid or the mezzanine equity that we call it. Ultimately, they're going to be converted into the equity into the later stage. But the point that the promoter is deliberating that while their plan was under deliberation, in their plan, they have mentioned for a contribution in the equity through equity makes them a more compliant plan to the evaluation metrics. They got an additional 10 marks as compared to the other bidders while the resolution plan was deliberated or analyzed, although they have not made their honor their commitment to contribute such amount in the form of the equity. Higher the equity, higher is going to be the healthy position, the finance health of the company. That is their point of argument, which the Supreme Court has rejected in its order of 26 September. Yes, although the CCDs are not exactly equity, but they have just overruled that this is not that strict point that needs to be considered for taking the company into the liquidation. Now, here the point also arises. See, from the perspective of the implementation of the resolution plan, we are talking about the COC, we are talking about the erstwhile COC. There is going to be a infusion of the funds in the corporate debtor. The monitoring committee or the monitoring chairman had distributed an amount of 19,000 crores to the lenders. Whether anyone is going to be look back, the remaining amount is going to be contributed or not? The answer is no. Whether that amount is actually needed into the company, that is again a question mark, because the business has revived on its own and there are going to be significant cash flows arriving into the company itself. That amount might not be required to be contributed. So the Supreme Court bench has says the point that is being raised by the promoters and the directors are not relevant to consider whether the amount required for the working capital is actually contributed or not, or whether it is being contributed in a specific form or not. Fair enough?
Okay, Akhil, let me mention this also. So on the aspect of locus standi, friends, what exactly happened is, because at the end of the day, who can file an appeal? Now, appeal can be filed if you just look at section 62. The right to file an appeal lies with the person aggrieved. The word used is person aggrieved. So
Right.
JSW and the COC, they typically argued that appeals were just an attempt to obstruct the revival process. But Supreme Court looked at section 62. They say, look, a person aggrieved can file an appeal. So now the question was whether the promoters, you see, come within the range of persons aggrieved or not. So they actually acknowledge that the promoters cannot automatically be excluded from locus because their legal rights as guarantors or stakeholders are affected. They have given a personal guarantee, so naturally they have got a right onto that. So therefore, the Supreme Court said that, look, we are not dismissing the appeal outright for want of locus. The court decided that let us examine the appeal on merits and also factoring in whether there was an obstructive conduct of the ex-promoters during the CIRP or not. So Supreme Court typically drew a balance and reaffirmed the principle. So what is the principle which was affirmed? That promoters should not interfere with the CIRP to protect their interest. But it also accepted that they may still qualify as a person aggrieved in certain contexts when their guarantor liabilities are at stake. So that is on the locus. Now, coming to the interesting part, which Akhil just now mentioned, particularly the upfront infusion of funds, the promoters argued that JSW had promised to infuse 8,550 crores as upfront equity. That is what the amount is, 8,550. But in reality, they also mentioned that, look, they have only contributed 100 crores, which is infused in cash, and the rest of the amount has not been, because they say and JSW contended that, look, we have infused via compulsorily convertible debentures, CCDs, which are there. And since the CCDs are mandatorily converted into equity, now they, in the corporate law, these are treated as equity instruments and not as debt instruments. It's not a loan which is given to the company. So that is what, and the approval of the plan and the scoring and the marking of the plan lies within the commercial wisdom of the COC. Because typically, when they mention that they're going to bring in 8,500 crores upfront as part of equity, naturally they got higher scores. So now bringing only 100 crores in cash and 8,450 in terms of convertible debentures. So that was the objection. But ultimately, the Supreme Court held that JSW fully met with the upfront equity infusion obligation by issuing the convertible debentures, now which will legally qualify as equity. Now, since the COC had approved it and accepted the infusion, the judicial interference in COC's commercial decision is impermissible. That is what the Supreme Court says, and the promoter's objections were rejected. Yes.
So the next issue, the fifth one, is relating to the validity of the resolution plan clauses. So if you see in the first paragraph, it is being captured in the resolution plan clause 3.1 allowed JSW, the SRA, a flexibility in the plan implementation timeline, making it subject to the condition like regulatory approval, government clearance, and unforeseen delays with the approval of the erstwhile COC. What the plan is trying to communicate in case they require some regulatory approval, for example, the CCA approval or some government clearances, they might delay the implementation, but with respect to the approval of the erstwhile COC. Now the promoters has argued in length that whether such clause can be allowed, whether such clause is considered in contravention to the spirit and to the law of the IBC. That is what is being discussed in detail, wherein in the second May judgment, the Honorable Supreme Court took a very strict stand and mentioned that the clause 3.1 granting an open-ended position or a flexible timeline was contrary to the time-bound scheme of the IBC. Whereas in the latest judgment, the Honorable Court has clarified the position, although they have mentioned that resolution plan cannot override the IBC timeline. The clause 3.1 was valid only if read it within the limited sense. That is only a limited flexibility that has been given to the SRA for the implementation of the resolution plan. And they have rejected the interpretation that has been taken erstwhile by the Supreme Court, considering that this clause gives GSW an indefinite time. So, Makhija ji, anything that you need to add in this?
We can move on to the next point. I think this is clear.
Yes. So the issue number 6 is relating to the OC's payout, the payment that is being meant to be paid to the operational creditor. Like in any other insolvencies, there is already limited recovery to the operational creditor compared to the financial creditor. They have been allocated an amount to the extent of the liquidation value only. And in most of the matters, the liquidation value is not sufficient to meet the financial creditor itself. The OCs keep on objecting the plan that they should be paid according to the financial creditor in parity to the financial creditor also. The Supreme Court in its judgment has clarified that the rights of the OCs are very limited, which are statutory to the minimum under section, minimum amount that is being captured in the section 30 subsection 2 clause B, which is the liquidated value. And Supreme Court has also reiterated the commercial wisdom of the COC and categorically mentioned that this argument is not valid and set aside the plea of the operational creditor who were expecting a payout for an amount equivalent or in proportion to the financial creditor. So this stand was already been clear, so nothing more to deliberate. The another issue that has been discussed is relating to a contingent claim of one of the operational creditor. There was an undergoing arbitration is there. The arbitral award was being challenged and the resolution professional has considered the claim as a contingent claim or a contingent creditor has not been admitted. If the claim has not been admitted, then the proportional amount in the resolution plan is being not offered to them. The deliberation was whether the claims which has not been final adjudicated can be considered later on once they get adjudication, or whether they could be kept outside of the preview of the resolution plan and no payment is being made and only going to be considered as contingent without any recovery. Supreme Court has categorically ruled it that the classification of the contingent creditor was valid. There is no objection to that, and OCs cannot reopen the claim post approval of the resolution plan by the Honorable NCLT. So, first of all, the operational creditor has a low recoveries, a low say in the entire process, and in case their amount is still not been crystallized, their that limited amount can again not going to be admitted under the resolution plan by the resolution professional and going to be categorized as contingent creditor. Fair enough?
Okay, Akhil, here you see the points are slightly, I think we need to really explain here. Friends, what happened is there was one creditor by the name Jaldi. Jaldi INC was there, which was treated as a contingent creditor. Now, why it was treated as contingent creditors? Let's understand the background. Jaldi typically relied upon four
Ashish
foreign.
sir, your voice is very low, Ashish sir. So sorry.
I think some people are able to hear me.
Yes, yes, it's okay, sir. Fine.
I think everyone is
All
able
right.
to
We are
hear
able to
me.
hear you
Yes,
properly.
yes.
So let's continue. So Jaladi typically relied upon being an operational creditor. They relied upon four arbitral awards, and RP admitted 151.37 crore as OC claim. And under the plan, now what was the problem which was there? The problem was that if the claim is crystallized, you will get 50%. This was mentioned in the plan itself. If you are a contingent creditor, you will get 10%. So naturally, at this stage, the operational creditor who was there, whose claim was considered as contingent, naturally they objected that, look, you are paying 50% to the others and only 10% to me. So we have to look at the parity. That was it. That was it is there. Of course, Jaldi in the Supreme Court judgment also says that this creditor shifted its stand before the NCLT. At points, it described itself as contingent. Then later on, they wanted to get the full OC treatment. Now, friends, let us try to understand, very important. Foreign arbitral awards, are they decree? Can they be considered as a decree under the law or not? A foreign award is deemed as a decree only after Indian court finds it enforceable. So you have to file an application. A foreign arbitral award person will have to file an application in an Indian court. And Indian court, if it finds that it is enforceable in India, then it is only deemed as a decree. Otherwise, it is not considered. So therefore, the Supreme Court relied upon this legal provision of Section 49 of Arbitration Act, and they said that if it is not executable, it is not a crystallized decree. If it is not a crystallized decree, then it is to be treated as a contingent claim only. So, and in a contingent claim, if the contingent creditors have been paid lower amount than the other creditors, which is absolutely fine. This is the commercial wisdom of the COC. So Jaldi, because Jaldi, what has happened was, there are more facts to it, but I do not wish to burden the participants with more facts. They withdrew. The Jaldi had filed actually an application for enforcement proceedings before Calcutta High Court, but they withdrew those enforcement proceedings without an Indian enforceability finding. So unless there is a finding, the foreign arbitral awards are not considered decree. So friends, this is a very interesting judgment, and you must follow this. If somebody files a claim with a foreign arbitral awards, first you must ask them, have you gone to the court and give me a finding whether it is enforceable in India or not? If it is enforceable in India, only then you will treat it as a crystallized claim. Otherwise, you will also treat it as a contingent claim. And being a different creditor than the normal operational creditor, well, differentiation can be made in the resolution plan. So this is what the Supreme Court decided. They said classification of Jaldi as a contingent creditor stands. And they say this is a question of fact. There is no question of law. So therefore, their appeal, because they also filed an appeal, their appeal was dismissed on this particular ground. Okay. Yes, Akhil, we can go to the next point now.
Right. So the next point is relating to the pre-CRP dues. So there is a lot of deliberation has already happened to this topic, where there has been categorically captured that pre-CRP dues cannot be paid. And in this matter, considering the company is a going
Akalji, just one
concern,
small thing. Akalji, just one small thing. So we have to close it by, I think, 5 p.m. So make sure that accordingly the
sure,
next
sir.
session
Sure,
is after us.
sure, sir.
Yeah.
So, the pre-CRP dues in this matter, they are the two operation creditor, Medicarrier and the Darcel Logistic Limited, who claimed that during the CRP, they are keep on continuing providing their services, and they have also been received the invoices that they have issued for a period prior to the CRP also, and for a period for the services for the invoice raised during the CRP period also. Later on during the CRP process, the resolution professional has identified basis the various account reconciliations, basis the preparation of the financial statement, that the operational creditor are adjusting the amount for the dues relating to the CRP with the payment with the dues that has been outstanding as on the CRP date. The resolution professional intimated them and mentioned that the claim, the liabilities, the services, the invoices that are for the period prior to the CRP date should be considered only as per the approved resolution plan, and the payments that has been made during the CRP period will be adjusted only against the services that has been provided within the CRP period. They tried to argue that they have received a promises or assurance from the resolution professional that their pre-CRP dues will be taken care of. The Supreme Court has clearly denied their argument and mentioned that the pre-CRP dues will be considered as per the approved resolution plan only. And for the services providing during the CRP, they have a right to fully claim that amount as a CRP cost that has appropriately been taken care of by the resolution professional. So their prior debt, prior dues stand extinguished to the extent not offered in the resolution plan.
Okay, Akhil, I'll just mention this. Friends, what was the issue here? Pre-CRP dues, naturally. So Medi and Darcel, those were the creditors. What is stated here is that these are the two operational creditors, Medi and Darcel. Now, they argued that they were promised pre-CIRP dues as an incentive to keep supplying the goods and services during CRP. Probably RP promised them. We don't know. We don't know the actual facts, but that is what has been claimed. Now, they pointed out that based on this promise by the RP, they continued to supply the raw material or whatever goods and services were there for about 10 months. And such pre-CRP services were also paid. So 10 months, the RP also paid them, because during the CIRP, supposing you have funds, so naturally you are paying them. But then later on, the resolution professional, he reversed that course. And the RP claimed that the payments which I made was a clerical mistake. And he issued a corrigendum saying that they would instead be treated under the resolution plan, and they are not squarely honored. So typically what was happening was that there were certain pre-CRP dues were there. They said you continue to supply and then I'll continue to pay you the pre-CRP dues also. Well, whether he did that or not, but even if he did that, probably it was wrong on his part. So that is on the basis of the assurance, they said, okay, we will continue to supply the goods and services during the CRP period. Well, what is the Supreme Court reasoning? Supreme Court reasoning is that number one, there is no COC written agreement. He said, please show us the written agreement. Number two, whether there was this agreement or this arrangement was approved by the COC or not, where they promised that pre-CRP dues will be paid outside the resolution plan. So even though the Supreme Court noted that some payments were made, but RP, they said he quickly corrected them and adjusted those payments. So because the continuous supplies were being made, so they were treated as being paid against those supplies during the CIRP period. So the court typically stressed that under IBC, pre-CIRP dues can only be addressed as per the resolution plan, not outside it. So the court dismissed both of them, the appeals which have been filed by both of them. So friends, what is the principle which was reinforced? Which probably everyone knows. I think there is nothing new in this. No pre-CIRP payments can be made, right, during the CIRP.
Right, sir.
Everyone has to file a claim. This is very clear. So I don't know whether this issue should not have arisen, but yes, there could be a problem if the RP promised them. We don't know. That is what they have claimed. Then the promise was also wrong. This should not have been promised. So please do not do that, my dear friends. But probably this is a case of 2017. People were also not clear what is going to be done. So based on this assurance, they continue to supply goods and services. So I think this is.
Sir, payment of such pre-ARP
Sorry?
amounts, will it not amount to preferential payments?
Yeah, that is exactly the course correction was done by the RP after probably after the legal advice. He was making payments of the pre-CRP dues, which he should not have done it. See, where is the question of making payment and then typically claim later on these were clerical mistakes? Can it be a clerical mistake? So this is a blunder actually which has been done if it was done. But anyway, Supreme Court typically ignored it right now and they said sorry, he corrected it, so therefore we are not looking at that right now.
Right.
Yes.
So the next point that was argued by the guarantors, that there is a delay in the implementation. What does that mean? The plan got approval by the COC in 18, which requires an upfront payment to the creditor for an extent of 19,000 crores. Upon the NCLT approval, the implementation didn't happen as agreed in the plan. The SRA argued that this is due to the legal hurdles specifically mentioned relating to the ED attachments and all, for which a parallel proceedings were being initiated, and later on the Honorable Supreme Court was in between and mentioned to for detachment of such assets. In the Supreme Court judgment of the 2nd May, the bench has taken a very strict stand and found it that JSW has not made their commitment for the fully implementation of the plan, since the plan was never under being stayed. When the plan was approved by the NCLT, it was approved subject to some conditions, and it was JSW only who has appealed this plan to the NCLAT. The Supreme Court 2nd May judgment has mentioned that even if you want to appeal that plan, parallelly you should implement it to the extent of what has been approved by the NCLT, which requires the immediate payment to the lenders. And Supreme Court judgment of 2nd May has upheld the argument of the promoters and rejected the arguments of the JSW. In the latest judgment, this Honorable Supreme Court has agreed that these delays are beyond the control of the JSW. They are not of the JSW default. They are primarily relating to the delays that are relating to the legal proceeding and external to the JSW as well as the COC control, and ultimately approve the resolution plan. Right, sir? Anything that you want to add in this?
No, absolutely. I think you have brought out very succinctly, but let me also, just extend that argument. Friends, what was earlier argued, I think Akhil has pointed out very rightly, that earlier the Supreme Court said that, look, there was no stay. There was an appeal which was pending before NCLAT. There was a stay initially, but it was lifted later on. So if there is no stay, why didn't you implement the plan? So why you did not implement the plan? So that was the observation of the Supreme Court in the earlier judgment. But here, of course, Supreme Court has not said too many things on this. They have, talked about that their CBI and ED proceedings were going on against Bhushan Steel and its former promoters, which led to the provisional attachment orders worth rupees 4,000 crores. Then NCLAT also stayed the implementation for several months, though the Supreme Court admitted in this judgment also that it was later on lifted. But then in the next sentence, they are saying multiple appeals kept the plan in limbo. So while the appeals were there, so they have remained little silent on this. probably not agreeing with the earlier judgment that look, once there is no stay, pendency of appeal does not matter. That is what the earlier judgment said, which probably I believe they were also right in their sense. But here the Supreme Court has not offered any more comments on that. But typically they have arrived at a conclusion that look, JSW cannot be faulted with. The delays were not on account of this. So, and the delay does not invalidate the plan. The delay which was caused by regulatory and judicial obstacles and they were handled in cooperation with COC. So therefore, Supreme Court chose to ignore. But friends, what is the lesson which we are learning? Please remember, and this is for everyone, if an appeal is pending, no stay is there, I believe the implementation cannot be stopped. It should continue. Of course, here the credit has been given to JSW, but in future, probably Supreme Court may take a different stand based on certain different facts and circumstances. So I think it really weighs on the facts and circumstances of each case. Here they referred on CBI, ED proceedings, and they mixed up all these issues together. Okay. Yes, Akhil.
Right. So these are the few pointers that I plotted down to be discussed in a session of 60 minutes. Now,
Okay.
one question that I would like to ask you, sir. Sir, whether the judgment dated 26 September is ultimately the final judgment, or whether this is also subject to any further appeal or a review. If you just highlight your wisdom, whether the promoters still have a chance to reach an higher bench or any other remedy that they have.
Okay. See, as far as the bench is concerned, no further appeal is possible in Supreme Court. Typically, what happens is there is a chance of a review, and this was typically a review which was filed. In fact, on the review, they admitted it. That said, all right, we will review the whole judgment. So therefore, they set aside the earlier judgment. So the chances of taking another chance is not going to arise now, because JSW is now probably in control of everything because they have already paid the full amount. So I don't think promoters stand any chance after that. Okay. Of course, they can have their legal remedies. They can file, whatever they wish to do. But as far as we are concerned, this is over because there is no higher bench. In Supreme Court, this is not like single bench or division bench. Every bench is consisting of two judges only. So I don't think all roads are closed. They could have filed a review, but this is itself a review. So review of a review is not possible unless there is an arithmetical or a clerical error on the face of the record. So I think all doors are closed. So this needs to be implemented.
And something related with curative petition and all, if that could be one of the possibility or chances, can help us understand what is that and whether that is the feasible one.
See, curative petitions, if you look at the history of the curative petitions, Akhil, 99.9% are dismissed. So curative petitions are where the courts have made a huge mistake, ignoring certain, legal aspects or other thing. But curative petitions are very hard to maintain and hard to win. So I don't think promoters will typically stand a chance, right?
Okay.
So that won't be there.
Got it, sir. So that is the discussion on the first part. Thanks everyone.
Okay.
Over to you, Makhijaji, please.
Thank you. I think Mr. Sandeep Chitkara is there or not?
Yes, Sandeep is here.
Friends, before we hand over to Mr. Jalesh Grover for the second part of the webinar, where we are talking about how to handle the real estate matters of CIRP, I would like to just simply mention, which I have been repeating. I would like to request everyone to please register for IBC Conclave. IPNet is organizing that IBC conclave on Saturday, 1st November at New Delhi. The theme of the conclave is very interesting, empowering IPs, strengthening the court. This will be a full-day national conference, which will bring together judiciary, regulators, senior professionals, bankers, and academicians under all one roof to deliberate on the latest developments and also challenges in the IBC ecosystem. All participants will get 4 CPE hours. Naturally, you will also get insightful sessions with top experts, great networking opportunities, and also a chance to be a part of one of the most influential IBC gatherings of the year. So the conclave will feature along with several eminent speakers also. Registrations are open. I have shared the link in the chat box. It is also available on IPNet website. So I will encourage all members, IPs, and all other persons to block the date 1st November and register early to avail the concessional rates and also secure your seat. So join us for the day of learning, collaboration, and inspiration at IBC Conclave, empowering IP, strengthening the core. Personally speaking, I look forward to welcoming you all in Delhi. So thank you so much, friends. Mr. Chitkara, if you are there.
So yes, sir. Am I audible, sir? Am I audible?
Yeah, you are audible. Please take over from here. Thank you.
Actually now there is one query from the member, or
Yeah.
sorry, the attendee. So whether only the members are allowed to attend this very IP
No,
conclave? So it is open for everybody.
It is open for everybody. It is open for non-IPs also. It is open for non-IPNet members also. So we are not making a distinction. Even everyone can attend. So I think it will be a good thing if you have passed. Mr. Pradeep Badi says, "I've just passed. Membership is awaited." Congratulations to you on passing the exam. So please come and do attend. It will be a great opportunity, sir. Thank you so much.
So, hello, Mr. Grover. We
Hello,
welcome you
good
to
evening.
this interaction. So, Jalesh Grover is a known name in the IBC. He has an enriched experience into resolution, restructuring, and surfaces since very long, since decades. He's based out from Chandigarh and actively been seen into the NCLTs in the northern part of India and much places also. Sir, I welcome you. Since Chitkaraji needs to introduce you, he's not there, so I take this opportunity to welcome you. Please.
Yeah, good evening, everyone.
Would
So
be
I will
happy
take
to
one
learn from
moment to share my screen for the presentation.
Are you able to share it, sir?
Yes, sir. I think I'm taking help of my person. I'm not so good.
Yeah,
for
I
this
think
thing.
everyone is waiting for you to hear from you.
Yeah.
Friends, in the meantime, may I request everyone, if it's possible, if you can open your videos. I think it gets a better interaction and we see all smiling faces. I think it's always good. Yeah. Otherwise, what happens is I'm also talking to blank screens. Yeah, now it's looking very good. Yeah, we can take a picture also now. Like, let everyone smile. So say cheese. I think a fantastic picture. Thank you so much. I think, friends, as far as real estate is concerned, it's a very typical kind of a CIRP. A lot of issues do come. I think most of you must have done that, and many of you have faced that also. I'm told Mr. Grover has handled quite a few real estate matters, and a lot of issues which come up, they have been able to solve it. There are a lot of issues which have come up, like project-wide CIRP, whether that is possible or not, and appointment of the AR. Then there was a question whether AR can be removed or replaced or not. In now new IBC bill, now we are also getting some solution that yes, he can also be replaced. A lot of issues have come up, a lot of issues have been resolved, but there are many other concepts, like somebody has got a decree in his hand. So whether that should be considered as a claim or not. A lot of problems are coming. Differentiation is also coming, whether what amount to be paid to those kind of people. There is a Mansi Brar judgment which talks about speculative investor also recently of the Supreme Court. So I think many issues are there, which probably I think Mr. Grover will be able to take it up. Yes, sir. Are you ready, sir?
So I will take a moment to share the screen. My team is going to do that, but in the meantime, I will start the.
Yeah, please do that, sir. I was just filling the space.
Yeah. So I will start the presentation, and my team will share the screen in the meantime.
Sure.
Good evening, everyone. So I will be little bit explaining my experience in real estate matters. So in fact, this will be my personal experience only, and some people might find it that this thing has not been written anywhere in the act or regulation. But what we do, we always prefer a best practices to be done. Like I invite all my home buyers in my COC meeting. I think very few people does that, and people feel that it's always a chaos. So in my meeting, there is never a chaos. So 100, 200, 300 home buys are always present in the meeting. And I always give them opportunity to pose questions, discuss the matters, and then they are all are very happy. I also conduct, other than COC meetings, I also conduct meetings with home buyers. Other than that, my AR calls the meetings, and then they invite me for discussions. And it takes me a good opportunity, a good experience to interact with them on regular basis. And they also feel very confident that their RP is always available with them, always available with them for any queries, any questions they need. So by numbers, if you look at around 22% are the CRP, in CRP are the share of the real estate sector in 22%. And as a ballpark figure, as per Google, more than a lakh of home buyers have always got their houses in the CRP due to IBC. So this amendment for home buyers to be treated as financial creditors, this came up in 2018. And with this amendment, the home buyers can now can file an application in NCLT for initiation of CRP, and they are treated as financial creditors. So some people criticize that this amendment is not correct and this should not have happened because real estate does not find a solution in CRP, in the IBC. So we can never find one solution for all the problems. So there are always some ifs and buts in everything. So even we also feel certain problems, certain issues on daily basis in the matters for which we do not have any answers right now. But after handling so many real estate matters, I have been doing around 15, 16 matters as of now. We have resolved more than 7 matters we have already resolved. And we feel that most of the issues are now settled or being settled. And since this is an evolving jurisdiction, jurisprudence, so I hope that in near future, I think the screen is shared now. Okay.
Yes, sir. The screen is visible.
So certain provisions under IBC, like financial debt, it has been defined by IBC Second Amendment 2018 through an explanation stating therein that any money raised from an allottee under a real estate project is a financial debt with a commercial effect of borrowing. IBC Amendment Act 2020 established a threshold for home buyers to initiate a CRP under Section 7. So here it has been decided that an application must be filed jointly by at least 100 allottees or 10% of the total allottees in the same real estate project, whichever is less. Both of them, whichever is less. And it should be a same real estate project. It should not be over number of projects. As financial creditors, home buyers are part of COC and the key decision-making body during the CRP. And here also it has been criticized a number of times that this type of COC does not have commercial wisdom. Of course, it is correct to a larger extent, but what I have observed so far that in almost my every matter, there are certain home buyers who are quite intelligent. There are always some advocates, some chartered accountants, some company secretaries, some bankers also. They always form a group out of them and they always have some say in the COC. They read the newspapers, they read relevant judgments also. And then there is AR. So as proposed in the regulation, AR is required to be appointed as per Section 25A, where the rights and duties of AR are mentioned. So for AR appointment also, as nothing is mentioned in the regulation that how an AR be appointed. So what we do, I am sharing my personal experiences. What we do, we normally search out the IBBI website and for the areas where the project is located or from where we know that most of the home buyers must be there, because the AR should be from the same address same type of area where the most of the home buyers live. So what we do, we search out the IPs having their registered offices living in that area, and then we send mailers to them. And after we received consent from them, we search out that who all have done any real estate matters, who all are not so busy also, and who all are some experience in real estate. And out of that, we try to offer the 3 choices to the allottees so that they can choose one of them. So AR is the main person. AR is the bridging gap between the RP and the home buyers. So RP has to circulate the notice agendas to the AR, and AR has to circulate in turn to all the home buyers. So AR should conduct a meeting with the home buyers prior to the COC meeting, so that AR should know the views of the home buyers, should have their consent or their opinions on the matters to be discussed in the COC meeting. Of course, it has to be voted later on by the allottees. So there are 2 type of versions also. Some of the ARs, they conduct a meeting prior to the COC meeting, and then they take the views of the majority home buyers, and after that another voting is again conducted to finally vote upon the agendas. So both precedents are going on in the market as the people go along. Next. So for voting also, the majority, AR has to cast his vote based on the majority voting of the creditors, and if more than 50% home buyers cast a vote in favor or against, so accordingly that agenda gets approved or rejected. So there are certain regulations, amendments keep on coming in this matter. So in a real estate project, so right, this regulation 4E, this has just recently come. So this regulation says that the possession can be handed over to the allottees if any allottee gives a request to the RP, and if they have performed their part in the agreement, of course, with the approval of COC only, not without the approval of COC, then the RP can hand over the possession. We have been doing this process since long, about 4 or 5 years back. We took approval from our COC for completion of the flats and for handing over the possession. There were no such regulations as on that day. But they were receivables from the allottees in a small project. We had 2-3 projects in that company. In a small project, the receivables were 3-4 crore of rupees, and only small work was pending in the flats. So what we did, we completed those flats, we handed over the possession, done the registrations, and collected those receivables. So ultimately, we were able to meet out the CRP cost out of that. So now, since this regulation now comes up, so people should take the approval of COC under Regulation 4E, and if there is the occupation certificate is available with the project, with the site, and RP can complete the units if possible. So only small work can be possible through RP. Of course, we don't build the complete structure. Only where the structure is completed and small fit outs are pending, we only go for that. Only that is easier for us people to do this process that we normally do. And in one of my project, there is a lot of work pending. Some 2-3 towers are nearby completed, and other remaining towers, there is a lot of work. What we are doing in that we also, there is no occupation certificate available with us, so no utilities are constructed as of now. What we did, we took approval of DTCP for the construction. So DTCP people, they inspected the site, and they prepared a list of all the towers, what work can be done, what work can't be done. And then they gave us approval for construction. Of course, we gave them undertaking that before handing over the possession, we will apply for the occupation certificate. We will get the occupation certificate from them. Only after that, we shall hand over the possession, not without that. And then we committed also that at that point of time, note now, at that point of time, when we have the receivables from the home buyers, then we shall also pay the EDC and IDC if the plan is not approved by them. In that case, that matter, the plan is approved by COC and it is pending with NCLT. We people know that NCLTs are taking time these days. Daily NCLT also is working half day, all the benches. So, and due to so much pressure with NCLTs, it is very difficult to get the plan approved in a short span of time. So then for enhancing the home buyers representation, there are some other amendments in the regulation. There is a facilitator appointment. Along with the AR, the regulation says that if there are large number of writers in class, like more than 1,000, in those cases, there can be facilitators along with the AR. So the purpose of this is that when there are the large number of writers, it is very difficult for AR to discuss with all of them to handle their issues. So that is why this amendment is there, so that if there are large number of writers in class, facilitators can also be appointed, so that the home buyers interact with the facilitators, and facilitators in turn interact with the AR. So a facilitator can be appointed only if a subclass with at least 100 creditors request it after the first COC meeting, and a total number of no more than 5 facilitators can be appointed for the entire COC or any subclass. And the facilitator will also get a fee of 20% of the fee of the AR. And a facilitator can also be replaced if recommended from a majority of the members of their class. Then regulation also says now that to have an effective CIP and effective resolution of the home buyers, so competent authorities should also be invited in real estate projects. This regulation amendment came because of the reasons of Noida authority. Mainly, there have been so many difficulties faced by the Noida real estate projects. Noida and G Noida, due to their dues, they are always objecting to the resolution plan. So that is why this amendment has came, that these authorities should be invited in the COC meetings, RERA authorities, Noida or Huda or DTCP also, because in Haryana, DTCP is there, in Noida, UP, Noida authorities and G Noida authorities are there. So whosoever are the land owning authorities or land leasing authorities or RERA or DTCP, those authorities should be called in the COC meeting, and they should be made aware of the process, going on process. They should be made aware of the claims of the allottees, the difficulties of the process, and whatever help RPs can interact with, can get from them, they should be facilitated. And also then those people will come forward for submission of claims also. Otherwise, claims comes very late in the process, and which also impacts the resolution of the project. Then there's a report is required to be prepared by the RP on the real estate development rights and permissions, and basically the status of the land also, and all the permissions. So RPs are required to prepare a report within 60 days of the insolvency commencement date. And this report then is required to be presented to the COC. And after taking the views of the COC, then it has to be filed with NCLT also. So some more regulatory developments like exemption from liquidation estate. There is an amendment in the regulation which says that flats for which home buyers have taken the possession before the liquidation process begins, their units will not be included in the liquidation estate. Then possession with COC approval, I have already explained. Then regulation relaxation for allottees group. So to facilitate a faster resolution, so it has been stated now that any allottee associations or groups that represent at least 10% of 100 allottees, they can, if they wish to submit their plans, so there shall be relaxation in eligibility criteria for those associations. This association process or builders registration plan, this has been now in practice a lot. So the first time when this plan was put up, so the other creditors, they objected to this process because there was an association, they were not having the net worth with them. They were not able to submit the EMD also. So there were certain objections to such type of resolution plans in the past. So that is why this amendment came, so that the buyers group, in some of the cases where there is not much juice available in the project, so very few number of resident applicants come, and the resident plans they offer are also not much lucrative for the allottees. So that is why this regulation came up. In those scenarios, home buyers can themselves prepare a resolution plan. They can come together. They can also contribute some capital also, or took some bridge loan, or there are always receivable from the home buyers. They can collect that money, and with the money they can be able to complete the projects also. So that is why they can submit a resolution plan. Because of the difficulties being faced in the resolution process, so some judicial solutions have also come up. Of course, success of these solutions is always a challenge. Project-wise resolution is one part where certain orders are there, where some NCLTs have initiated project-wise insolvency only, allowing viable projects to continue while troubled ones undergo resolution. So it has become a success already. So a number of projects, only projects, not the whole company, they have been resolved through this way. Of course, there are certain difficulties associated with that. The project has to be demerged from the company, and those solutions, there are solutions in the market for that. Then there is reverse CIP, where the existing promoter management, they have offered their plans and they have been allowed to complete the project after bringing in additional funds with them. So, but in reverse CRP, there are very few cases which have emerged successfully. Otherwise, there have been many failures so far in reverse CRP. Certain judgments related to the real estate project. So there is one Ramesh Malhotra and others versus MR MGF Land Limited. It says that material changes to buyer's agreement require express consent of the purchasers, like one-sided clauses or unilateral actions taken by the developers. So those were declared unenforceable and struck down as unfair. So what people do, what these builders have been doing in the past. So after entering into a BBA, after that there are sometime an addendum issued, and in the addendum they make some changes in the agreement due to this addendum, and those changes are always for the benefit of the builders only, not for the allottees. So what happens, we always, when we go to the bank and we take some loans, we never read out the loan agreement. In these matters also, it happens that the allottees never read out the builder-buyer agreement, and only they look at the price and in how many months the unit is being received will be possible to them. So they sign the agreement. Nobody reads out the detailed terms. Only when there is a default, only when there are delays, people goes on reading those documents, and then they find out that the clauses mentioned there are totally one-sided. So they don't get any benefit out of those agreements, and only it is the builder who gets the benefit. Next, in Pushpanjali Construction versus Seema Jaiswal, there is a UP RERA judgment. Here, RERA ruled that any change in project terms or buyer entitlement without the purchaser consent is invalid. So delay or alteration of contractual terms without agreement entitled buyers to refund with penal interest. So if there is a delay in the project delivery, then it will attract some penal interest. So this UP RERA declared this. And it's the judgment Godrej project versus Anil Karlekar. So this says that the principles of fairness and transparency in builder-buyer agreements and unilateral forfeiture of amounts and amendments of developers were restricted and subject to consumer protection scrutiny. The Mansi Barar, Fernandez versus Shubha Shah and others. So Supreme Court has come strongly in this judgment on NCLT, NCLATs, even the government and RERA, on everyone, stating that none of these are taking care of the home buyers. And they say the right to housing is the fundamental right to life under Article 21. So that is why the home buyers should be able to get their houses. And what they say that the genuine home buyers represents the backbone of India's urban future, and their protection lies at the intersection of constitutional obligation and economic policy. And they have suggested certain measures in this judgment. Of course, time will tell that how these suggested measures are being taken care of. Then next is Amit Mehra and another versus Pawan Kumar Garg and others. So it says that there was a claim received by the RP initially, and then this claim was somehow not verified. And again, a revised claim was called, and that revised claim was treated as belated claim. And in the registration plan, there was a differential treatment for the belated claims. The home buyer was not getting the unit and only getting a 50% refund of the case. The Supreme Court stated that nothing doing, so the claim was received well in time. So it has to be treated as per the other claimants, and the unit has to be delivered to the claimant. This Himanshu Singh and others versus Union of India and others is a very, very landmark judgment where the Supreme Court has thrashed the builder-buyer, the builders and banker nexus, and they stated that the subvention scheme being floated by the builders are totally under nexus with the bankers, and they have come harshly on both of them, on the bankers also and on the builders also. And around 21 or 22 builders have been identified, and number of banks also. One of the bank, they had given more than 2,500 crores of loan under subvention scheme. Certain home buyers approached High Court, and after High Court, they have approached Supreme Court. And now Supreme Court has already formed an SIT of different states, wherein there are income tax people, there are ED staff and police staff also. So already FIR is being registered against many builders. So in the meantime, they have put a stay on any adverse for these home buyers, and all those nexus are being opened up now for the home buyer, for the builders also, and for the bankers also. So hopefully this will give some boost to the affected home buyers. So what the Supreme Court has done so far, though, so since the matter is still going on in the Supreme Court on regular basis, so far they have just issued the guidelines for SIT and how this SIT will work, and how, if any FIR is required to be registered, how these have to be registered. Another hearing was there about 10 days ago, about a month ago, wherein the Supreme Court has now stated that whatever FIR is required to be filed, immediately it should be filed. So another matter which is impacting the home buyers in a larger prospect is the belated claims. So now there are regulations 13.1 which says that if the claims are not received within 90 days or by issuance of RFRP, whichever is later, then the claims shall be treated as belated claims, and it has to be regulated by Regulation 13(1), which says that all those claims shall be treated as RP shall mark those claims admissible and non-admissible, take reasons for late filing of the claims, then put up these claims in the COC, takes recommendation of the COC whether to put these claims in the list of creditors or not, and after that file an application with NCLT for continuation of delay. And then the RAs have to treat these claims in the resolution plans separately. So there have been multiple judgments on belated claims so far. However, no conclusive judgment has come up as yet. Of course, there are judgments that these belated claims should be treated in the plan. So treatments, some people are providing in their plan and some are not providing any treatment or a partial treatment in the plan. So what RAs, clever RAs are doing that they are offering some amount, some principal amount or partial amount for the belated claimants. Of course, but my view is that all these claimants in a real estate project, the ones which the RP has the details with him, all those genuine home buyers should be treated in a similar way. If the units are being offered to other claimants, the timely claimants, the belated claimants should also be offered units in the similar way, so that there will be lesser litigations later on and plans will be approved earlier. Some practical challenges regarding the claims of the home buyers other than the belated claims, how claims are to be addressed, verified, admitted. So first is rate of interest to be admitted by RP. So if there are some contractual rate of interest, then that rate of interest has to be treated. If there are no contractual rate of interest, then if there are some court judgments, the rate of interest mentioned in the judgment that has to be taken. If there is no court judgment also, then the regulation says that 8% interest be taken. And then there are questions always. People say that my bank is charging a compounding rate of interest, so I should also be given a compounded rate of interest. Nothing is mentioned in the regulation, but when there is nothing is mentioned, so there is a judgment which says that if the compounding word is not used, then simple rate of interest be taken. So simple rate of 8% is required to be taken for calculating the claim percentage. And otherwise also this percentage is utilized only for the purpose of calculation of the voting share. And it's up to the RA to offer any amount of rate of interest to the creditors, claimants, while submitting a plan. Then there is service tax and TDS issues are there in the claims. So service tax, sometimes service tax is deducted or TDS is deducted. So those has to be not to be treated in part of the claim, because the departments, TDS department, service tax department, they will also file claim if those are not deposited by the CD. So those claims will come from the service tax department and TDS department. Regarding verification and admissibility of claim by the RP, NCLT in the case of Island FS states that if any claim cannot be verified with reference to the evidence presented and the books of accounts of the CD, the registered professional cannot admit it. So in another matter, NCLT has held that improper maintenance of the records of the CD, the applicant homebuyer cannot be made to suffer. The RP must verify the authenticity of the supporting documents that have been filed by the claimant in support of the claim by other means within the boundaries of law. So one judgment says that if there are claims in the books of accounts, only then it has to be admitted. Other says that even if there are not books of accounts, then claims have to be admitted basis the claim documents. So my view is that whatever best RP can admit should admit it. If RP feels that even if there are not books of accounts and the claim documents are genuine, they should admit those claims. And if there are no claims and books of accounts are there, so in those scenarios also, RP should disclose all those claims which have not been filed to the RA, so that RAs can propose for those non-claimants also in their resolution plan. In one of our matters, what we did, we, after the approval of plan by NCLT, so we requested the RA to take care of these non-claimants. What RA did, he again published a newspaper advertisement and he gave 30 days time to the persons, to the home buyers who have not filed their claim earlier, to file their claim at that point of time after approval of plan by NCLT. So 30, 40 claims came during that period and he honored all those claims in the similar way as the original claimants were. So compound interest I've already explained. So claim for interest on assured returns. So in one of my matters, there were assured returns mentioned in the builder-buyer agreement. And then there was interest also. The people also expected that there should be interest on those related on assured returns also. So we took a legal opinion and we found out that yes, they are right. So because assured return was to be given to them on regular intervals on monthly basis. And that is why, since there is loss of interest because of non-payment of assured return, interest has to be offered for non-payment of assured return also. Some critical challenges being faced for the resolution in a real estate matter. So there are operational criteria, supplier of building material. So, or even in some of the cases, some building materials always lying at the site also, which is unpaid building material, or the construction material, some machinery or shuttering material. So those create issues while we go for a resolution plan. Then there are completion agreements by the builder for different type of allottees, different type of completion agreements are there. The recoveries are always staggered for different category of home buyers, different recoveries process is mentioned always. So, and in some of the cases, there are normal creditors also and home buyers also, other than home buyers financial creditors also. Those type of cases are much difficult to resolve because financial creditors, the secured financial creditors, they feel that they have the voting rights. They should get the maximum chunk, and they feel that they are the secured creditors. They should get the maximum benefit out of the project, and they are not bothered about whether the home buyers will get their units or not. In one of matter, the financial creditors are scheduled nationalized bank. They had got 52% voting rights, and home buyers had 48% voting rights. So plan could not be approved without any of them. Home buyers were of the view that they should not get any escalation in the cost. And financial creditor was of the view that since they are secured creditor, the whole liquidation value will go to them. And if the companies gone into liquidation, then they will get a better recovery. So I had to travel to their MD thrice just to convince them that if you accept the resolution plan, you will get the recovery much faster way. And if you opt for liquidation, home buyers will fight tooth and nail, and the matter will go up to Supreme Court, and only then you will be able to get something once the liquidation is decided. So it is better that you take the offer. And then we discussed with RA also, and we negotiated between all of them. And after negotiation, we able to get that plan approved. We increase some offer to the bank also, and basis that we able to get that plan approved. Some roadblocks in this process also, valuation complexities are there. Realistic value, asset value calculating for the partially completed projects is always a difficulty. So land parcel, these land parcels are not normal land parcels. Sometimes land parcels have also got the licenses with them. So this is a significant challenge for the valuation. Then funding gap, securing interim finance for ongoing construction during CRP proceeding. This is a really difficult process. So recently only we have been able to get interim finance in some of the matters. around 4-5 years ago, there was no concept of interim finance. It was very difficult to arrange. Of course, we able to get interim finance in those days also. But nowadays, little bit easy is there, but still market has not developed that we able to get interim finance for construction also. Of course, for CRP, post interim finance can be received, but not for the construction process. Then there are regulatory conflicts. So no one is ready to give any approvals during CRP without having their past dues. RERA is another process. We have been trying to get RERA renewal in one of our projects since last 6 months or so. So we took 6 months to complete the file for RERA. Just imagine that how difficult it is, how much their formalities are. So finally, we have submitted our file. So I don't know how many months they will further take just for the renewal. So we are not selling the units due to that reason. Of course, we might not be interested in selling the units during this process. But just imagine if there is no cash flow available and they are ready to move units available in a project, and just the RPs could not sell it because of the RERA renewals. That is quite difficult, but it's happening as of now. Delays in the timeline is you all people are aware. So IBA is publishing this that 330 time limit has passed much earlier. So nowadays average time is 600 days or so. Of course, these timings are mostly the real estate matters only, and non-real estate matters might get resolved even earlier also. So in all of my matters, I have approved the plan from COC before 330 days. Only in one of the matter it has crossed 270 days. Otherwise, in most of the cases, from COC approval, we have taken in 270 days only. Of course, it's now pending with NCLTs, and NCLT, we are not sure how much time they will take to provide the approval. So some reforms have come up already, some are on the way. So like this criteria classification reform, so secured versus unsecured status is already there for the home buyers. So it has clarified the process. The resident status has been now clarified. And this liquidation part, that in case of liquidation, the already handled units should not be part of the liquidation estate. This is now clear. Some tailor-made procedure are already developed in real estate insolvency, like project-wise insolvency is already there. And now there are coming up home buyer focused resolution plans, and there are the good resolution applicants also in the market. Interim funding mechanisms also to a larger extent are available, and people have find out ways and means also for the debt. I persuaded my home buyers to contribute their remaining receivables so that we have the funds available with us for the construction. Then we don't need interim finance from outside. So it's an interim finance only, but we got it from inside only. And of course, we offer them some rate of interest also, and we able to got the requisite finance. Timeline optimization is also now happening, since some of judgments have come up which have clarified a number of things. So that is why the timelines are also, we have been able to somehow reduce the timelines for approval of the plan till the COC time. So as of now, we have achieved some milestone already. IBC has brought much needed discipline to India's real estate sector, with home buyer gaining unprecedented rights and protection. Judicial innovations like project-wise resolution and reverse CRP have created practical solution. However, certain challenges still remain as of now. Regulatory overlaps, these complexity, Noida Authority issues, and these issues by DTCP department, they don't allow for renewals of licenses without making the payment for the full period till the application for renewal is filed. Rather, they expect interest for the period of moratorium, CRP period also, and they don't budge for those things. They feel that till the date of payment, they should get the interest. So what future outlook is, I think that a balanced approach combining creditor recovery with home buyer protection, supported by sector-specific reforms and enhanced regulatory coordination, will surely strengthen the India's real estate insolvency framework and restore market confidence. But I feel that except these regulatory bodies, most of things have now come to quite a settled position. And with passage of time, these regulatory bodies are also started listening to the RPs like DTCP. Since DTCP, I work mostly in Haryana, so DTCP authorities I know very well. And luckily their office is also in Chandigarh only. I have met a number of times the director DTCP. And we have made them agreeable to much of the difficulties we are facing on regular basis. Now they have developed an in-house NCLT cell who are always willing to cooperate with the RPs and for filing of claims or finding out the outstanding dues. Even I remember in earlier days, we were not able to get the outstanding dues from the DTCP department. And even if we want to get some drawings from them, because normally cities don't cooperate. So we never got any information from the DTCP 4 or 5 years ago. But now the moment we ask anything from them, their legal department, they provide the requisite information quickly. That is all from my side on this real estate presentation. So I invite the members, if people have any questions, any queries, any practical challenges. So to my best ability, I may be able to give answer to them.
So this was a very good presentation, Jileji. So and this has given us whole lot of practical experience which you have while handling a number of real estate insolvencies. So this is always good to hear you. Now, as Jileji has said that maybe any kind of questions are welcome. So let us ask him if any of us.
Can I ask one question?
Yes, please. Yes, please.
Yes.
Yes, Mr. Vetrana.
So there is a provision that belated claims, if they are acceptable, non-acceptable, should be presented to COC, and then accordingly they should be clubbed together and go for NCLT approval. Let's say it is acceptable as per RP, but COC denies it. COC says don't admit anything. In that case, what should the RP do?
Sir, in my view, still RP should approach NCLT.
But sir, it says no with recommendation of COC.
Yes, so it doesn't say that if COC does not recommend, you should not go to NCLT.
Sir, it says no with the recommendation. Then if it is not recommendation, then
yes,
it automatically says that.
So COC has recommended not to be included.
Correct.
At least
Then
NCLT should be informed at that point of time. Otherwise, later on, what will happen? All those claimants whose claims have not been admitted, they will go to NCLT.
Should the RP go or let the person go?
No, I think
my suggestion this resolution, sir, this regulation came in so that there is less burden on NCLT.
Yes.
Correct. So that there are not 9, 10 people there. So together, RP can collate everyone, 6, 7, 8, 10, whatever number, and we file one application. Correct.
Yes.
So the thought process was fine. But in home buyer case, they do not admit other claims. They say now whoever is late is late. Now in that case, RP, if I file is the same thing. Whether the other person files or RP files is the same thing, isn't it?
No, sir. If other persons will file, then there will be number of applications. If RP files, then there will be one application only.
No, so they keep coming. It's not that
that's true.
It has stopped coming, right?
See, there are now judgments which say that if the
your view is that even if they have rejected it and RP feels RP has to go.
Yes.
That's your call. Okay.
Yes. In all out of my 15 real estate matters and almost an equal number of other matters, only in one of my matters COC has refused for these belated claims. Otherwise, in all of my matters, I've been able to convince my COC, whether it was a home buyer COC or a mixed type of COC, I have convinced the creditors to accept this. Otherwise, there will be a lot of litigations, and which will ultimately delay the process. Today was my 2 COCs of real estate matter only, and I convinced my creditors, and they accepted that.
Fair enough. I got your. You are saying RP has to do it, so
yes.
Okay.
My view is that.
Fair enough.
Okay. So any more of questions from the attendees? So friends, please ask questions and let it be an interactive session.
Sandeep sir, there are a few questions in the chat box.
Okay, Namrata,
Okay.
can you read this
Okay,
out?
I will read out. Not an issue. I will open the chat box.
So there's a question on how to handle the promoter who has committed the fraud by accepting cash payment from the allottees and not accounting for the same in the books, whereas the allottees present the signed receipts for cash from the promoters. Should the RP accept the claim or reject?
See, frankly speaking, in one of our earlier matter, we accepted the cash receipts. So we verified those receipts in a proper manner, and we accepted the receipts. What happened later on? New receipts keep on coming up. The receipts which we can look at, that these receipts have been prepared now only. These are not older receipts. So what the promoter was doing, he keep on signing new receipts during the CRP. So immediately stop the process at that point of time. After that, we have not accepted any cash receipts. What we do in such matters, we collate those receipts and we file an application under Section 66 against the promoter for these cash receipts. But we do not accept the cash claims.
Okay. Thank you, sir. And if Noida Authority is involved in the CRP and if we venture into completion of construction and handover of possession to home buyers as per 4E, then how to handle dues of Noida Authority?
See, firstly, we need to approach Noida Authority firstly before doing this process in Noida as practically. So what I did, like I said that in Haryana, I approached DTCP and I explained all my problems, all my issues with them. I explained to them that I'm not having the occupation certificate, and I took permission from DTCP. And they had agreed that once the plan is approved, I will be making payment as per the claim. That is what I had agreed. Nothing more than that.
So I guess that answers that. And Sandeep sir, last question, then we'll have to close. Whether the ARs who are a part of the COC continue to perform till the date of implementation of the resolution plan, and they will be paid fees, if any, after the submission of the resolution plan.
No, only till approval of plan AR will be there. After the approval of plan, there is no COC, and that is why no AR is there. Then there is monitoring committee. AR can be part of monitoring committee. In one of my project, Homeby stated that AR be part of monitoring committee. We have made him part, but as monitoring committee, not as COC. So AR is on behalf of the Homebys in that committee after approval of plan.
Sir, I'm Shankaran here. But latest judgment in the JSW matter, the COC continues to be there till the implementation of the plan.
No, what Supreme Court is saying, that COC, since they have their funds to be collected to be recovered, that is why COC should remain there only. So once we make the monitoring committee, COC is always part of monitoring committee only. All the COC members or the majority COC member, they are always part of monitoring committee.
Right, sir.
Right, sir. Great. So any other
Yes.
question? So I think there is no question as of now. So Namrata, yes, you were saying something?
Yes, sir. Should I present the memento?
Yes. Please go for the memento. So I'm very thankful, and I just want to convey my heartfelt thanks to all the guest speakers.
Thank you, sir. Thank you.
So
Dilesh, this is memento. So you have given a wonderful presentation, and this speaks volumes about your experience in all kind of insolvencies.
Thank you, sir. Thank you, Sandeep.
Do we have Mr. Ahuja also?
Akhilji, are you there?
Oh, I think he's left, sir. Sandeep sir, we'll proceed with sending the hard copies. Sandeep sir, the hard copies sent to them.
Okay. So now This is actually, this was a wonderful, I would say, webinar altogether. Somehow, so there have been some technical issue on my side, and I couldn't actually moderate the session in the best possible way. So there have been numerous network failures. So now thing is that there have been 2 sessions, and both the sessions have been wonderful. So it's my pleasure to extend the vote of thanks to today's regarding the today's webinar on behalf of IPNet. So today's event has marked a new beginning in the IPNet, where we can proudly announce that we are providing opportunity to our active and willing members to come forward and join as guest speakers. Friends, let me extend my heartfelt thanks to Mr. Akhil Ahuja, Mr. Jalesh Grover, and of course, our IPNet president, Mr. Ashish Makija, for being the wonderful speakers today. So I would just like to convey that Ashish sir's commitment and visionary leadership has made IPNet a much sought after platform of great significance by the insolvency professionals pan-India. And I would also like to extend my thanks to IPNet team for the seamless coordination and tireless efforts behind the scene. Thanks to all the participants in the webinar, and your presence in the weekend webinars is testimony to vision and efforts of IPNet. Thank you once again. Last but not the least, I would also like to again request all the members present and otherwise the other members who can be approached. So I would like to request to register for the IPNet, this IP conclave, which is going to be held on 1st of November. And this is to be held at the India Habitat Center, New Delhi. So I would again request all the attendees to register for this very event. This will be, so we have actually be presenting over there the galaxy of speakers. So this will be a wonderful session over there. So again, thank you so much for attending this very event. Thank you so much.